Silence in the class, please. Settle down right now and open your notebooks. Today, we are dissecting a definitive, recurring 16-mark exam question for your KSLU examinations, and I demand your absolute attention. The question is, define transfer of property. Explain the essentials of a valid transfer. What properties cannot be transferred? Now, this is a multi-part question, and answering it haphazardly, well, that's just going to fetch you mediocre marks. To secure a university rank, you must structure your answer precisely. So let's dive into this explainer and build your perfect answer script step by step.
Securing those maximum marks begins with this exact synopsis. 1. Introduction to property law. 2. Defining transfer of property. 3. Essentials of valid transfer. 4. Non-transferable properties. 5. Landmark case laws. And 6. Conclusion.
Starting with Section 1, Introduction to Property Law.
Now, once your synopsis is neatly ruled off, you begin your introduction. Listen carefully, you do not write vague philosophies about property here. You must immediately boldly state the foundational statute, the Transfer Property Act 1882. This specific 1882 Bare Act lays down the strict, inflexible rules for the lawful transfer of property between persons. It's the absolute bedrock of your answer. If you fail to mention the year 1882, the evaluator will just assume you lack basic statutory awareness, and we can't have that.
Moving on to Section 2, Defining Transfer of Property.
When you reach this heading, you must place Section 5 in the dead center of your page. Make it impossible for the examiner to miss. Then, take down this exact wording. An act by which a living person conveys property, in present or in future, to one or more other living persons, or to himself and one or more other living persons. I am pausing here to heavily emphasize this point. This exact wording must be memorized, word for word. Put it in quotation marks and underline it in the exam hall. Never try to paraphrase statutory definitions.
Right. Let's dissect that phrase, living person, from the definition. You must write down the term inter vivos, which means transfer between living persons. Explain to the KSLU evaluator that this law exclusively governs inter vivos transactions. It doesn't apply to transfers by operation of law, like inheritance or insolvency. And it absolutely does not apply to wills, which only take effect after someone passes away.
To properly finish defining the section, break it down into these key points. First, transfer must be between living persons or inter vivos, just as we discussed. Second, property may be movable or immovable. The Act covers both, though, as you know, specific chapters deal exclusively with immovable property. And third, transfer may be present or future. You can convey rights immediately or stipulate that the rights will pass at a later date. Detailing these three elements shows the evaluator you've fully digested the Bare Act.
Next is Section 3, Essentials of Valid Transfer. I'm announcing right now that we're moving to the core weightage of your essay. Missing even one of these essential elements is going to cost you marks. Take note of Essentials Part I. Number 1, competent transferor under Section 7. They must be competent to contract and actually entitled to the property. Number 2, competent transferee. They just need to be capable of holding property, which can actually include a minor or a company. Number 3, transferable property. It must not be prohibited under Section 6. And number 4, lawful object and consideration. The object can't be illegal and consideration is obviously required in transfers like sales. Now, class, I want you to underline the contrasting requirements for the transferor versus the transferee. A transferor has to be fully competent to contract, meaning a major of sound mind. But a transferee? A minor can be a transferee. A transferee simply needs to be capable of holding property. Highlight that distinction.
Continuing our list, Essentials Part 2. Number 5, mode of transfer under Section 9. It can be oral or written, but registration is strictly required for certain transfers, like the sale of immovable property. Number 6, certainty of property. The subject matter has to be definite and identifiable. Number 7, intention to transfer. There must be a crystal clear intention to pass rights or ownership. Take note, Section 9 dictates the physical mode of the Act. The general rule here in India is that property can be transferred orally unless a specific law requires writing and registration. Furthermore, absolute clarity of intention is non-negotiable. If the intention to pass ownership is ambiguous, the whole transfer is void.
Pay close attention as we shift to Section 4, Non-Transferable Properties.
This section right here is a major trap for average students. They list a few random items and just move on. You must stress that Section 6 of the Act dictates exactly what absolutely cannot be transferred. You have to set up the jurisprudential contrast for the evaluator. Note the general rule. property is freely transferable, versus the statutory exception, Section 6 restricts transfers. Property implies alienability. You can transfer what you own. But Section 6 acts as a strict statutory barrier. It essentially says property of any kind may be transferred except as otherwise provided by this Act.
The very first restriction under Section 6 is a guaranteed examiner favorite, Spes Successionis. Define this Latin maxim very carefully. It means the mere possibility of inheritance or chance of heirship. Look, you simply cannot transfer the hope that you might inherit your father's property while he is still alive. You have no legal title yet, only a hope. Therefore, you have absolutely nothing to transfer. Let's systematically dictate the first 5 Section 6 restrictions. 1. Spes Successionis, that chance of heirship. 2. Right of reentry, which cannot be transferred separately. 3. Easement, which cannot be transferred apart from the dominant heritage. 4. Restricted personal interests. And 5. Right to future maintenance. Make sure the evaluator understands that these restrictions exist because these rights are strictly personal or intrinsically tied to specific properties. You can't just separate a right-of-way, an easement, from the land it benefits, and you certainly can't sell your personal right to receive future maintenance.
We finished the exceptions with Section 6, Restrictions 6 through 9. 6. Mere right to sue. 7. Public offices. 8. Salaries and pensions. And 9. Transfers opposed to nature or law. Explain to your examiner that public policy and natural law forbid the commercialization of these final 4 items. You can't sell your right to sue someone for damages to a third party. You absolutely cannot sell a public office, nor the salary attached to it. That would be completely against public policy.
Now for Section 5, Landmark Case Laws.
Let me sternly advise you right now, writing bare act provisions only gets you a passing grade. Citing landmark judgments is what actually secures the university rank. The first mandatory case is Jumma Masjid v. Kodimaniandra Deviah. Write this case down. In fact, draw a physical box around this case name on your answer script. Force the KSLU evaluator to look at it immediately.
Take down this case matrix precisely. Facts and background. Transfer attempted by an individual holding a defective title. Ratio decidendi, meaning the final verdict. Transfer by a person with imperfect title may operate under certain conditions. Relevance. Modifies the strict rules of transferor competency. Let me break this down. Earlier we said under Section 7, a transferor must be fully entitled to the property. But what if they have an imperfect title they transfer it anyway, and later they actually acquire the perfect title? Well, the court held that under certain legal doctrines, that transfer can still legally operate. It prevents the transferor from backing out. This directly links back to our earlier point on competency, showing you truly understand the nuances. Write this explanation clearly.
Presenting the second required case law, Gopal Lal v. Babu Lal. Write this down and demand the examiner's attention by underlining it boldly. Maximum visibility is key for a 16-mark answer.
For this precedent, facts and background. Dispute over the transferability of an inheritance chance. Ratio decidendi held definitively that Spes Successionis is not transferable. Relevance provides judicial backing to the Section 6 restriction on chance of heirship. When you write this in your exam, dissect how the court firmly applied the Section 6 restriction. The court invalidated any transfer based on a mere hope of succession. It cemented the rule that a chance of heirship creates no present vested interest in the property, and therefore it is completely void of initio if attempted to be transferred.
So, we've finally reached the end. But how must a student actually conclude this comprehensive legal analysis? You don't just abruptly stop writing, you must guide the evaluator into framing your final marks with a highly structured, authoritative concluding paragraph.
This is your conclusion. Note it down verbatim. A valid transfer requires competent parties, a lawful object, and transferable subject matter while respecting restrictions that uphold public policy and fairness. Write this exactly. It's the perfect, succinct wrap-up. It summarizes Sections 5, 7, and 6 in one elegant sentence. By presenting this level of organization, from a clear synopsis to statutory definitions, to essential elements, to statutory exceptions, and finally landmark case laws, you leave the KSLU evaluator with literally no choice but to award you top marks. But before we finish up today, consider this. As we enter an era of digital assets, cryptocurrencies, and virtual real estate, will these rigid, land-based 1882 restrictions still hold up? Or is property law due for a massive revolution? Think about that for your next assignment. Class dismissed. Study hard.